Thank you, Senator and Chairman and Senators. Thank you so much. I'm Darlene Byrne. I'm a district court judge in Travis County, and I have been since 2001. And during that time, I've heard in excess of 14,000 hearings and countless trials involving vulnerable children and families in the CPS system. I'm going to speak today about my concerns about the privatization and/or fragmentation of case management services at CPS, and the concern that I have about it hindering the department's accountability to court orders and ultimately doing a disservice to children and families served by the department. I want to make it really clear I am not speaking against community-based care. I am not speaking about that. I am speaking about privatizing case management and my concerns there, and that is all. Please do not privatize or further fragment the state's function of serving as the final safety net for our most vulnerable children and families. Case management, privatization, and fragmentation, from my point of view, will not fix the ills that the CPS system suffers, but will increase them and cost more money as this complex new system is implemented. The case management provisions of Senate Bill 11 will be more likely to hurt rather than improve the overall level of service we provide to children and families, because it impedes the fundamental role of the courts in ensuring the best interest of children by being able to hold the department as parent of those children accountable. Senate Bill 11 is structured, ironically, mirrors the structure that, at least in my court, the state abhors for children and families. By that I mean, in my court, the state frequently seeks to terminate biological parents' rights to their children when they bring them into the world and then wash their hands of them and all the responsibilities of a parent and expect other family members of the public to raise them. Senate Bill 11 seems to be the state's effort to do the same thing for the department, by the department taking the name of parent, but then divesting itself of the responsibilities that go along with being the parent, the case management, thus passing the accountability buck down the line. Judges are statutorily vested with the powers and duties of an oversight role that requires us to render orders with regard to best interest of children in the foster care system. To be effective, judges must continue to be able to hold the department, not a contractor, as a governmental agency accountable for carrying out the court orders. Currently, lawyers and judges can call the department to the bench, and I apologize, my time is up, so I cannot go.
You got a minute more, Judge,
Okay.
Go ahead.
The bench to account for failures and ensure that children are provided the services they need. We can hold the department in contempt if needed, and in this way our orders are an effective means to cut through red tape and to direct the agency immediately and urgently to do what is needed that day for a kid in crisis. In a privatized or fragmented case management system, however, this function of the court becomes lost, or at least significantly watered down, as the department points the finger at its contractor, and the contractor, who's not a party to the lawsuit, tells the court it has no jurisdiction over it to mandate anything for children and families. Contracted providers will be able to exercise broad discretion on the use of funds without having a fear of being held in contempt of court for any specific failures. Stripped of our current tools, and I apologize, I'm out of time.
Now you're out of time, but I think Senator Watson had a question for you, Judge.
How would you conclude your testimony?
He is my senator.
He's doing a
I
pretty
did
good
vote
job.
for you this year, Senator. Stripped of our current tools for ensuring accountability, the only resource of the courts will be to more frequently enter no reasonable efforts findings. And we haven't heard anything about that today. Those findings, if a judge makes those findings, this state loses every federal dollar for that foster care case in each case that a finding is made for the entire life of that case. Quite expensive. Lastly, I share the Senate Bill 11 authors aspirations to improve the CPS system, no doubt, such that it is more of a community-based system. I myself have been a vocal critic of the many recent failures of the state of Texas as a parent to its foster youth. We have allowed too many foster children to be further traumatized by our foster system, such as children sleeping on the floor of CPS offices, receiving insufficient services from overworked and underpaid caseworkers, and having too few foster homes, due in part to low reimbursement rates for quality foster homes trained adequately to do their hard job. Again, please don't privatize or further fragment the state's function as serving as the final safety net for our children and families. If you must do that, I encourage you to do it slowly and very deliberately in small increments that are proven with performance measures to gauge the success and, more importantly, the cost of implementation. We heard today that the impact system that you want improved is being stymied because of delays in contracts. I cannot fathom anything worse than I've got a child or 30 cases on my docket this next Monday, and I'm told that, you know, I can't get little Susie's clothing voucher today because the one contracted entity, you know, we've got a little squabble over here, and I can't make that happen. Well, I know if I've got the department in front of me, I can order them to do it by tomorrow, and it will be done. So that is what I worry about. You talk about this being urgent. It is more than urgent. It is past urgent. But if we continue to change the entire landscape of the CPS system every 2 years, CPS is scrapping and trying so hard to meet the vast changes that we make. How can you ever expect the government to keep up? You just gave them in December, I don't know how much money to hire a bunch of caseworkers. They're on it. It's going to cost this state $54,000 a caseworker when you change the rules by May for every one of those caseworkers that say, well, now you don't have a job. Go work for this nonprofit who has different rules, different obligations, different training modalities. So I don't think this is going to save us money. I think it's going to cost us a lot of money.
Thank you.
Thank you, Judge, for your testimony. Any other questions of the judge? We appreciate your testimony.